right, let's look at some cases where the courts have said fitness for duty evaluations the fitness for duty evaluation was lawful, it was right to have been ordered, and then we're going to compare and contrast that tomorrow morning, because we're going to be done here in about 7 minutes. For today, we're going to compare it and contrast it to those where the courts have said, are you kidding? No way, that was not appropriate to have a fitness for duty evaluation. Now, Sullivan versus River Valley School District, this is a classic landmark case in the world of fitness for duty evaluations. Sullivan was a teacher who was one of these pompous, paranoid kind of obstreperous, difficult, annoying, confrontational, conspiratorial-minded teachers.
I know him.
Yeah, you know, a lot of people like him. And his behavior really frightened the administrator for the River Valley School District and the board. Behavior became very inappropriate. So the administrator contacts the psychologist that they use for these evaluations and said, hey, let me describe the behavior, let me share with you some of the emails and other kinds of correspondence we've been having with this guy, and tell me what you think. You think we ought to be doing a fitness for duty evaluation. Here's the objective evidence of problematic behavior, and should we be thinking that there might be an underlying mental health condition, and might this person pose a threat? So the psychologist looks at it and says, I think there's very good reason for believing there may be an underlying mental condition. Don't know, couldn't determine that without doing an evaluation, but I think you're on very firm ground for a reasonable basis for suspecting that the person may, as a result of a mental condition, be unable to perform the duties of a teacher. Okay? So they refer him for a fitness for duty evaluation. The teacher refused, sued the employer for ADA violation, alleging that the fitness for duty evaluation requirement showed that the teacher, showed that the district regarded him as having a disability. Now, we haven't gotten into this, but if you know much about the ADA, you know that there are 3 prongs that will bring it into question. That was more true pre-ADA AA. Now it's just a given. But in the pre-ADA AA, you either have a record of having a disability, or they think you have a disability, or you have a disability. Any of those 3 prongs would work. That is, they regard you as having one, you have one, or you had one. So he's saying, because you sent me for a fitness for duty evaluation, you are regarding me as having a disability, therefore you're violating my rights by requiring this evaluation. The court said, what? Given that the employer, and I'm quoting, given that the employer needs to be able to determine the cause of an employee's aberrant behavior, this is not enough to suggest that the employee is regarded as mentally disabled. To hold otherwise would unnecessarily inhibit employers from an inquiry regarding the status of behavior on the part of an employee that the employer may perceive as inappropriate for the employment environment. Still, the court went on to say that the order must be justified by, quote, significant evidence that would cause a reasonable person to inquire as to whether the person was able to perform the job functions. The behavior cannot be merely annoying or inefficient. So that's Sullivan. You'll read Sullivan referenced a great deal in other court cases involving fitness for duty evaluations. Cody versus Cigna Healthcare is another case that is often referenced by other courts. Cody was a person who would do home health care visits, and she would go out in the field, come back into the office, and so they all worked in these cubicles. And she was weird. She would sprinkle salt outside of her cubicle. She would chant. She would call her supervisor at night, tearful, talking about how she was, didn't think that she could continue to come into work because she's having such problems. And her coworkers reported that during meetings she would draw spermatozoa in the margins of her notes. Now, I don't know how you know that's spermatozoa. I'd be thinking tadpole or balloon, but they apparently knew spermatozoa. Okay. Anyway, they thought all this was weird, and so they eventually referred Cody for a fitness for duty evaluation. And gee, surprise, surprise, Cody didn't think that that was appropriate. And so the court ruled that, quote, employers need to be able to use reasonable means to ascertain the cause of troubling behavior without exposing them to ADA claims. So, Cody, go for your evaluation. Yin versus State of California, another Ninth Circuit landmark case, which was the case in which the court determined that when health problems, and I'm quoting from the court, have had a substantial and injurious impact on an employee's job performance, the employer can require the employee to undergo a physical examination to determine his or her ability to work, even if the examination might disclose whether the employee is disabled or the extent of the disability. See if we can get another case or two in here. Sorry about that. That was Yin. And Tice versus Center Area Transit Authority. Tice sided with the Sixth Circuit Court in Sullivan and the Ninth Circuit in Yin by saying once an employee's ability to perform his or her job has been placed in doubt, an employer may require a medical examination with a doctor of its choosing. And the case of Rice versus Oakland, Ninth Circuit case in 1999, this extended Yin to mental health and compulsory mental health fitness for duty evaluations, noting that the employer need only have a, quote, reasonable basis for concern that the employee's mental health undermines the ability to perform job duties. I think we have time for maybe one more. And Donofrio versus the New York Times. The employee was gone from the New York Times for 3 weeks, absent. And the employee's physician finally contacts the newspaper and says that the employee suffers from acute stress disorder, and that's why he hasn't been in for 3 weeks. And by the way, he needs another 6 weeks of treatment before he can come back. If I add that up, he's going to be moving from ASD to PTSD soon. The employer said, maybe, we'll see. We're going to send him in for an independent medical examination to see whether or not this accommodation you're requesting, which is to not fire him, but to let him remain off for 6 weeks, whether or not that's a reasonable accommodation. And so they ordered it. He didn't want to do it. Go to court. Court concludes that the demand conforms to the ADA requirement of an interactive process. You may recall that the ADA requires that once they know of an underlying disability, that they have to engage in an interactive process with the employee. Now, normally the employee has to request it. That's the normal rule. But there are some circuits that say once the employer is aware of it, that burden shifts. That is, they effectively have been told. The employee doesn't have to move his lips. As long as the employer knows, they have a burden to explore, engage in an interactive process with the employee to see whether or not there might be some potential accommodation. And we've reached. Can I just finish these? Would that be all right? Would that be? Jim, am I violating anything
No.
terrible? Okay, because we're so close.
As long as they say okay.
All right, thanks. San Diego, is that all right? All right, thanks. Okay, I love this case, Fritsch versus Chula Vista, because very often attorneys that advise your clients don't want to do fitness for duty evaluations, and they think, we don't want to do that. Well, this is a case where Fritsch is a assistant city attorney for the city of Chula Vista, and Fritsch is in chambers with an opposing counsel, with the judge. And so the three of them are in the judge's chambers, and she just flips out, Fritsch does, at the opposing attorney, and calls him a pig that has a problem with women, and he's incompetent. Now, he may have been both incompetent and a pig that has a problem with women, I don't know. But her behavior apparently was outrageous to the judge. She was crying, and she was like completely flipping out. So he picks up the phone or writes a letter to the city attorney for Chula Vista and says, hey, your deputy or assistant has a real problem, and so, do something about it. So the city attorney says, we're gonna send you in for a fitness for duty evaluation. And she sues and says, no, I shouldn't have to do that. Court says, yeah, you do. And the court ruled, quote, her job as senior litigator required her to meet with opposing counsel and appear in court. An attorney should be able to perform those functions in a professional and calm manner so that she can focus on the best interests of the client's needs instead of her own personal feelings and sensitivities. Now, you could replace attorney with the word police officer, and it would be a beautiful recitation of exactly why, in many of these cases, that attorneys are opposing fitness for duty evaluations, why they should be. So if it's good for the goose, it's good for the gander. And I would submit, and I have often used Fritch with these attorneys, and they go, okay, all right, I got it. That you may find it persuasive. And the final case, before we end this discussion and move on to the one for tomorrow, is EEOC versus Amigo. Also, landmark, often cited case in fitness for duty evaluations. It's a First Circuit case, and aside from its importance, it shifts the evidentiary burden in cases where there's a public safety threat from the employer having to show that the employee is unable to safely do his job, where that's where the evidentiary burden normally lies. But the court in the First Circuit said that burden shifts to the employee when there's a public safety issue at stake. So Amigo was a healthcare worker who twice tried to kill herself, and I believe worked in a jail, if I'm not mistaken. I might be wrong about the setting. But in any event, twice tried to kill herself, handled medications, had access to medications that could easily have resulted in harm to herself or others. And the court ruled as follows: where the essential job functions necessarily implicate the safety of others, the plaintiff must demonstrate that she can perform these functions in a way that does not endanger others. So, I have up here one last case. We're not going to talk about it tomorrow because we're going to spend a fair amount of time on it. This is a brand new case out of the Ninth Circuit. Brownfield versus City of Yakima is a very important case dealing with what we call prophylactic or preemptive fitness for duty evaluations, and that'll be the opening subject tomorrow morning.